As we continue talking about bankruptcy, we're going to switch gears to the Chapter 11 bankruptcies, or the reorganization, as they call it. This is the chapter that the big corporations use. So you hear about it in the news. Airlines, GM has done it. They don't do it because they're insolvent. Most are very well solvent. They do it to negotiate debt with creditors or prevent lawsuits from happening, right? Because you get the automatic stay. We'll talk about that. So Chapter 11 provides the means by which corporations, partnerships, and other businesses, like sole proprietors, they can rehabilitate themselves and continue to operate free from the burden of having debts that they cannot pay. And this is, like I said, very common. The largest bankruptcy in U.S. history was in 2008 when the Lehman Brothers holding filed for bankruptcy. That's an investment bank. They had over $691 billion in assets. The second largest bankruptcy was Washington Mutual in 2008, right after Lehman Brothers had $327.9 billion in assets. They were a savings and loans holding company. This was as the result of the real estate market and the crash. WorldCom in 2002, $103.9 billion. That's a telecom company. General Motors in 2009. Enron 2001. So we hear about a lot of the big corporation bankruptcy. This is the common chapter that they file under. So what is reorganization? It's a plan for the adjustment of a corporation and its debt, the submission of the plan to the bankruptcy court, and the court's approval or rejection of the plan. So that's the whole concept of the reorganization. The plan is created by and between the creditors and the debtor. The plan includes what debts will be paid and those that will be discharged. And the key point is the debtor gets to continue business. So they file for bankruptcy and then they continue to operate the business while this bankruptcy is happening, okay? So the same principles that govern the filing of the Chapter 7 petition, remember I told you at the beginning all of this, the process is generally the same for each chapter. I'm just going to fill in the differences here. So the same principles that govern the filing of a Chapter 7 petition applied to the Chapter 11, which it starts with a petition, and that it could either be voluntary by the debtor, i.e. the corporation, or involuntary, where the creditors, based on those conditions that I had said under the involuntary petition, file for the petition. The automatic stay provisions apply. Like I said, that's one of the big reasons corporations file, is to avoid any lawsuits being filed against them. So the automatic stay happens upon filing. And then the same principles that govern the entry of the order of relief, meaning, okay, this is in proper form, so I am going to, the court says, I'll allow this bankruptcy to continue to the next step. So the question is, why do creditors agree? Why do they agree to plans where some debts are going to be discharged? Well, because they believe that the value of the operation of the business is greater than the value of the business if it's broken up and sold into pieces, i.e. Chapter 7, right? That's what happens when you file Chapter 7, you're liquidated, and then you cease to exist. So they agree to these things because the value of operating such a business like GM is greater than the value of that being broken up. The goal is to keep financially troubled firms in business, or businesses, keep the debtor to continue in business. So who is eligible? Oops, I guess I just kind of went over that in the last piece. So you have your petition. It's either voluntary or involuntary. The automatic stay, order of relief granted from the court, and then the debtor remains operating while the bankruptcy proceeding continues. So who is eligible for Chapter 7? Anyone who is eligible for Chapter 11 is anyone who can file for Chapter 7, plus the railroads. Remember, railroads couldn't file for Chapter 7. And I am going to draw a flag here where it says not eligible for Chapter 11 relief: stockbrokers, commodity brokers, banks, savings and loans companies. And now the question is, why can't they? Because usually they're indebted to folks like you or I. They're not just going to let them do those things and sell you stocks and then kind of, oh, sorry, it didn't work out, and later be discharged from it. That's the general backing behind it. Now, I just gave you some examples of the biggest bankruptcies. Washington Mutual, Saving a Loan Holding, Lehman Brothers Holding. I just told you they filed for Chapter 11, and now I'm telling you, but they're not eligible for Chapter 11. They're not eligible for the relief under Chapter 11. They filed for Chapter 11 so they can continue operating as a business, but before they get to the order of relief, where the court says, yeah, this is in proper form, we'll let you continue with the bankruptcy, something else happens. And in the case of Lehman Brothers, they ultimately liquidated. So they got forced to Chapter 7 because the government didn't bail them out. So they got forced into Chapter 7 and liquidated. With regards to Washington Mutual, who filed for Chapter 11 so they can continue operating as their business, they ultimately were bought out by JP Morgan. So they didn't get to the part where they were determining whether or not they were eligible. They just jumped in and filed to be saved from lawsuits, quite frankly, is what happened. So, Creditors Committee. That's the next step in all of this, and this is where the unsecured creditors come in. Sometimes there is a trustee, but the Creditors Committee, and it's a committee of the unsecured creditors, the court appoints this committee right after it orders its order of relief, meaning it says that this bankruptcy can continue. The committee is composed of the biggest suppliers of the business, or the 7 largest claims. Maybe there's not exactly 7, but who are the biggest creditors? The committee essentially functions like the bankruptcy trustee. They meet with the debtor. They do an investigation of the debtor's financial affairs. They determine if a trustee should be appointed or allow the business management to continue operating. It's kind of a catch-22. The same management of the business is, that brought them to bankruptcy is still kind of running the show, but they have to make that determination whether or not they would let the business continue to manage itself or if a trustee should be appointed. And if the committee believes that the management is capable of continuing to operate the business, no trustee. If they're not capable, they'll appoint a trustee. A trustee may be appointed anyway by the court if it's in the best interest of the creditors, regardless of management capabilities. So all of these things happened at the creditors' meeting. Generally, no order will be entered by the court without some sort of consent from the committee or a hearing from the committee. The court will want a input from the committee. And again, they'll consult with the debtor to determine and review their financial situation from there. So then the next step after the creditors committee is created is the reorganization plan. All right, the goal of the plan is to conserve and administer the debtor's assets in hope of an eventual return to successful operation and solvency. Okay, so this becomes a contract between the debtor and the creditors. And like I said, the goal is to conserve and administer the debtor's assets in hopes to return to successful and solvent business practices. So the debtor is the one who has the exclusive right to file this plan. Okay, they have this within 120 days of the court's order of relief. Nobody else can file anything. The first 100 days is for the debtor, the corporation, the business, to file the plan. It kind of gives them first crack. It allows the debtor to persuade creditors to kind of get on board with it. But after the 120 days, other folks involved can file a plan. The committee, maybe a single creditor. If there's a trustee involved, they can file a plan. But the plan comes from the debtor primarily. If the debtor doesn't file a plan, other things could happen. They could be forced into a Chapter 7. So the plan, what does the plan need? It must have certain criteria. It has to be fair and equitable. That's the overall global reason here, criteria, fair and equitable. It must designate classes of creditors under the plan. We've talked about different types of classes in Chapter 7. They may or may not be the same type of creditors involved in this particular bankruptcy, but the plan has to set forth designated classes of creditors under the plan. It must specify the treatment to be afforded to the class of creditors. The plan must provide the same treatment for each claim in a particular class. I'll give you an example in a second. It must provide an adequate means for the plan's execution, and it must provide for payment of tax claims over a 5-year period. So if there's taxes involved, the tax claims there's got to be a payment plan for taxes within a 5-year period. Okay? So for example, a reorganization plan might put employees who are owed back wages in one class, shareholders in another class, maybe unpaid suppliers in a third class, and we'll assume under my example that the plan calls for the suppliers to be paid 70 cents for each dollar. So what that means under this plan criteria is that all of the suppliers will get 70 cents on the dollar. Not some get 80 and some get 60. If there's a class that says these are suppliers and suppliers are going to get 70 cents on the dollar, each and every supplier gets 70 cents on the dollar. Okay? There might be a provision that provides for some creditors receive stock in place of payment of the debt. So the overall goal is fair and equitable. So next step. Oh, and there's my example that I just did. So then the next step is the acceptance of the plan. Once the plan has been developed, the creditors must accept it. They usually do that within 60 days after the debtor plan has been filed. The voting process is usually over half of the creditors in each class that's owed at least 2/3 of the total debt in that class. They must vote in favor. I'm just giving you some background. You just need to know the process. I'm not going to give you the number of the voters. I'm not going to ask you any questions about, now, how would these creditors vote? Just kind of giving you the overall picture here, and that's what I hope for you to get out of bankruptcy, because it's actually there's lots of little nuances in the laws. So even if all these classes of creditors have accepted this plan, the court still has the ability to refuse to confirm it if the court does not believe it's in the best interest of the creditors. So even if the debtor proposed the reorganization plan, the debtor and all of the creditors have voted and accepted it, if the court reviews it and doesn't think it's in their best interest, the court can still reject it. But on the other flip side of that, even if one of the classes of creditors accepts it, maybe some reject it, the court can still agree to it, or cram down is what they say, the cram down plan provision. The court can still say, yep, I'm approving it. They could still do it. So it's kind of a catch-22 on the voting. Confirmation. This is where that cram down comes in. So we have the acceptance of the plan. Now we have the confirmation. This is getting the court's overall approval. The court must confirm the plan for it to be binding on all the parties. So generally the plan must have been proposed in good faith, and that is proposed by the debtor in good faith. We've discussed good faith. The court must deem that the reorganized business this is what it determines its confirmation on, that the court must deem that the reorganized business will likely succeed and be unlikely to require any further financial reorganization. So that's number one. And all members of every class must have received no less value than they would have had in a Chapter 7 liquidation. So I believe that's where the confirmation, where it's not in the best interest of the creditors. If the creditors would have gotten more through a liquidation, the court is not going to confirm it. So they have to get at least what they would have received at a Chapter 7 liquidation. At least that or more, because if they could have gotten a better deal out of a Chapter 7 liquidation, they might not be able to reorganize. And then discharge, okay? If we're dealing with an individual debtor, like a sole proprietor type business, they get a fresh start, right? The entering into and making a plan itself does not discharge the debtor from the debts, okay? The plan has to be complete. Once the plan is completed, i.e. the debtor has paid everybody off in accordance with that plan, then they'll be discharged with regards to anything that was agreed upon would be discharged. The things that cannot be discharged are those items that we talked about at the end of Chapter 7 that do not apply for denial of discharge, i.e. taxes, liabilities due to theft, embezzlement, those types of things, alimony payments. We already went through the list of the non-dischargeable debts, that still applies here. Corporations, they can get discharged at any time after confirmation because the whole point is a reorganization from their claims, and they get the discharge from all their claims that weren't protected underneath the plan, and then they get to continue with their business. But the individual is the one getting the fresh start, and they're discharged from everything at the end, so that's why the plan has to be paid in full. So that is a Chapter 11, the differences relative to Chapter 7. Otherwise, everything would be similar to the Chapter 7. In Chapter 13, we'll tell you the differences here, what makes it a different type of bankruptcy. This is the adjustment of debts for individuals. Who's eligible? Individuals. And these individuals must have regular income to have their debts adjusted. They can't owe more than, and this is the number, $383,175 in unsecured debt, and no more than $1,149,525 in secured debt. I don't know why, they just cannot round off the number, but that's the current number that they cannot have in debt. And the debt must be owing and unpaid, meaning they're behind in their payments, creditors are looking for their money. They must take their credit counseling course before filing. So the credit counseling course applies here too. Filing a Chapter 13 is less expensive and less complicated as a Chapter 7 and a Chapter 11. Under Chapter 13, the debtor can remain and continue business, so if it's a sole proprietor, and they can maintain most of their assets. And the majority of any debts that are discharged are usually done by 3 years, but this process can last up to 5 years. So how does it work? Only an individual can file, and it only can be by voluntary petition. So there's no creditors can come in and file an involuntary, only by voluntary petition. Only individuals, including sole proprietors, so not partnerships or corporations. The debts must be owing and unpaid at the time of filing, i.e. they're behind, they're not current. They take the credit class. The same principles apply relative to the automatic stay. Once upon filing, you get the automatic stay from any sort of litigation or creditors seeking payment or repossession. The court will, if it's your petition's in proper form, the court will issue an order of relief saying this bankruptcy as a Chapter 13 can continue, i.e. if they've looked at the means test here. And then the court will appoint a trustee. A trustee is always appointed in a Chapter 13. So the individual's plan. Only the debtor may file a plan under 13. That's it. If it doesn't file a plan, the creditors can force the debtor into an involuntary proceeding under Chapter 7. But the only person is the debtor who can file the repayment plan. And what they're saying is this is how, after they determine what their disposable income is, under the means test that we had gone through the last time, this is how I propose to pay off my debts within this 5-year time frame. Remember we did the calculation times 60 months? That's how we base this plan on. So only D files. And then there's a creditors meeting, and this is where the debtor submits the plan of payments for debts. It may provide for the payment of all obligations in full, or for payment of an amount that's less than 100%, but it must provide these things. It must agree or give assurance that it will turn over all future earnings or income of the debtor to the trustee as is necessary for the execution of the plan. Full payment of all claims entitled to priority, such as taxes or secured debt, okay? Payments must be completed within 3 to 5 years. 3 years is the minimum, 5 years is the max. Must give same treatment of each claim within a particular class of claims. Remember, all secured creditor, maybe they're all secured uncredited on the credit cards, getting 70 cents on a dollar, but same treatment of claims in all classes. The debtor must act in good faith at the time of filing the petition and the plan. It has to disclose everything, all assets, all liabilities, per the code. And unsecured creditors do not vote on this plan. They can object to the plan being approved, but they don't have to vote on it. So if the court approves it, so if it's approved, it's accepted, and the approval is based on good faith, the disposable income is going to go towards paying the debt within the statutory time frame. So this is the court's confirmation. The court approves it, and it must be in good faith. Secured creditors, however, have somewhat of a say on the approval end, or what the court will take into consideration in determining good faith. Specific secured creditors, the court is going to approve the claims regarding them if the secured creditors have accepted the plan. Yeah, we agree to this. Or the plan provides for their liens to continue. If we're talking about a home or a car or a boat or an ATV or something that may have a security interest. Or if the debtor has just surrendered the collateral and the secured creditor has taken the collateral back for satisfaction of the debt before the court's approval. With regards to secured creditors, that's what must happen and what they will consider. So then we have our trustee who's going to be appointed and carry out the plan. So within 30 days of approval, the debtor has to turn over any payments to the trustee, who will then distribute the funds to the creditors in accordance with the plan. And as long as the plan is being carried out, the debtor is free from any lawsuits or any lawsuits. Yeah, what is the debtor free from? Well, the plan is being carried out, and this is being chased by creditors. Okay, free from lawsuits, repossession, any legal action by the creditors. So the bankruptcy proceeding is still open for 3 to 5 years, because that's what our plan obligations are. But during that time frame, they're free from being chased by the creditors. So what happens if the debtor doesn't pay? The court can transfer the case for liquidation to Chapter 7. What happens if the debtor loses their job? No fault of their own. It's not that they're refusing to pay. They can actually file for a modification of the plan. The creditor or the trustee can do that too. And if if the debtor applies for a modification and the creditor and the trustee don't agree, the court might hold a hearing to determine whether or not they'll allow for a modification of the plan. But even if there is a modification of the plan, it does not modify the time frame. It still has to be done within 60 days. It cannot go on forever. And then what happens when the plan is completed? Discharge. Right after the debtor makes all the payments under the repayment plan, the remaining debts are discharged, with the exception of those non-dischargeable debts that we had already talked about under the Chapter 7 liquidation. And I'm also going to point out here, the exemptions aren't technically They are considered under a Chapter 13, but the whole point of a Chapter 13 is for the debtor to retain their assets. They don't turn their assets over to the trustee to be sold or liquidated. The point is to get some relief from the debt that they have. If they have disposable income, where it's kind of giving them like a sort of payment plan to get out from underneath the debt that they have. They can still retain everything that they have, their Van Gogh painting or other items, jewelry. Maybe they have a classic car in the garage. They don't have to turn any of those things over if they have disposable income to be able to make a 5-year plan to pay off their debt. So the liquidation, so we're not really talking about what's exempt and what can you keep and what has to be turned over. We're just talking about putting together payment plan, payment options for debts. So that is the basic umbrella of bankruptcy. The book does a good job on this chapter as well. Certainly in the real bankruptcy world, there's a little bit more nuances and caveats and a few more hearings. I think I might flowchart. I do. Here's a Chapter 13 flowchart. You meet with your attorney. There's credit counseling. You get the filing fees and information. Get your certificate. File the paperwork. File your plan. There's a hearing, confirmation hearing. And then you have your payments continue for approximately 3 to 5 years, assuming what your plan has, and it's gone by without objection. But it's a very short process, a lot shorter than the Chapter 7 ends shorter, but the process of getting to the end is a little bit longer than Chapter 13. But then the Chapter 13 remains open for as long as you have to pay off your debt for your payment plan. So anyhow, that is bankruptcy. Next topic is going to be real property.